Members, it is the appointed time and we have a quorum. The third meeting of the Bills Committee on Basic Housing Units Bill is called to order. Before we start, I have received a joint letter from several FTU members. It is asking the administration to reply to the views collected from those who live in SDUs. I will circulate this letter and wait for a reply from the administration. The next meeting will be held at 10:45 today, so there shouldn't be enough time to receive a reply before the next meeting. But still, we invite the administration to give us a reply on the views collected. Item 1, meeting with the administration. Mr. Tony Jie has raised his hand. Mr. Jie? Yes, Chairman. Concerning a point raised by Mr. Andrew Lam on the last meeting, concerning the minimum living conditions of BHU, concerning standing codification order and other statutory order. So for orders like inspection of windows, besides the communal parts of the buildings, there are also window inspection orders issued to individual flags. So if there are outstanding window inspection orders, will the SDU still be considered meeting the requirements? And also, when fire safety improvement orders are issued to the building, while the orders are not issued directly to the flags, but that would affect the overall safety of the building. So for SDUs in these buildings, will they be allowed to register as BHUs? I only seek a clarification from the administration. Thank you. Ms. Winnie Wong, any reply? Thank you, Chairman, and good morning, members. Concerning this question, we require the registered professionals to inspect the interior of the flags. So only orders issued to the flags would be considered. But still, our teams will also look at the overall situation of the building. For example, when there are fire safety improvement orders issued by the FSD to the building as a whole because of fire risk, then that would be a factor we consider as well. For the registered professionals, their responsibilities is only limited to orders issued to the flags. Chairman, thank you. Still, I hope there would be a set of guidelines for the professionals to follow during their certification work. And also, I hope that the regime would be clear to the landlords, the tenants, and so on. Thank you. There being no other questions, let's return to the clause-by-clause scrutiny. Please refer to page C3432 of the bill. On the last occasion, we have discussed the specified fee or prescribed fee. Now we will continue from tenants and tenancy. Mr. Chan, please. Thank you. Next definition, tenants, includes a subtenant. And then tenancy means a lease entered into orally or in writing and includes A, an agreement for a tenancy, and B, a subtenancy. Next, reference building plan. Now, later on in Clause 3, we will go into details of this. Next, just a moment, please. Yes, please continue. Cap 7. Next, Cap 7 means the Landlord and Tenant Consolidation Ordinance, Cap 7. Next, Cap 95 means the Fire Services Ordinance. Next, Cap 95F means the Fire Services Fire Hazard Abatement Regulation. Cap 123 means the Buildings Ordinance. Cap 123F means the Building Planning Regulations. Cap 128 means the Land Registration Ordinance. Cap 572 means the Fire Safety Buildings Ordinance. Cap 585 means the Land Titles Ordinance. Please pause. Mr. Tony Jie has raised his hand. Now we will start the clock now. 4 minutes, please. Mr. Chair. Thank you. Now clarification. Now see at page C3448, licensing will also be included. Now this regime does not cover small houses. So what about home lodgings? Will they be included as well? So first of all, we have to define what home lodging is. If that's a residential unit, if the building plan is amended, and then the divided units can be let out individually, then they would fall within the definition of subdivided units. Now for B&B, if there is a license issued by the Home Affairs Department for guest house or hotel, then it would enjoy an exemption under Clause 4. So the license must be acquired from the Home Affairs and Youth Bureau under the Hotel and Guest House Ordinance. Otherwise, they will be covered by the regime. Now for B&B let out to visitors, the operators may be in breach of this law and also the hotel ordinance, but they would be outside of the regulatory regime of BHU. Now, it is not easy to get a license from the HYAB. So will more people, do you expect more operators to register their flags as a BHU to be let out as a B&B? That depends on the purpose of the flags. Now we have a definition for residential tenancy under our bill, and also there is a definition under the Hotel and Guest House Ordinance. For short-term tenancy, under the length of 1 month, they would be regulated as well. So it's not the case where you can select the most frictionless pathway. Please continue. Now about reference building plan, I know there will be more details in Clause 3, but can you tell us the major purpose of the reference building plan? Ms. Wong. Now in Clause 3, we will explain why we need to have the definition for reference building plan. First of all, we need to have a definition for subdivided units. That's why this regime comes into existence. So we need to compare the original building plan with the modified building layout to see whether the flag falls within the definition of SDU. So we need to look at the original building plan. So that's the reference building plan, based on which we will make a comparison with the latest layout to see whether the flag qualifies as an SDU. Ms. Doreen Kong. Thank you, Chairman. Now, the definition for tenants includes subtenant. So compared with Cap 7, regulated tenancy, that's the same. However, in this bill, there are provisions where if the registration is cancelled, the tenants can receive a compensation. But that's different from Cap 7. Under Cap 7, even the closest relatives of the tenants are also protected. But that's not the case here. So immediate family members are not protected, as well as in Cap 7 in this bill. Ms. Wong. Thank you, Chairman, and thank you, Ms. Kong. We have considered this issue as well during the drafting stage. You're right, in Cap 7, subtenant includes family members. We haven't specified the same here because we only seek to regulate the hardware of the subdivided units under this bill. So the point is whether the BHU is let out for residential purpose. Now for Cap 7, it's more about tenancy protection. So it's all about putting in place safeguards in the lease to protect the tenants. So we think that by defining subtenants as the person who signed the lease, that would be sufficient. Now, there may be some exceptional cases. After the passage of the bill, if the flag is unregistered, or if the registration is cancelled, then there will be a termination of tenancy agreement. Then the compensation will only be awarded to the subtenant, that is the signatory of the tenancy agreement. So I hope you would reconsider this point. According to the definition of regulated tenancy, not only subtenants are covered. Now for SDU tenants, their tenancy is protected under Cap 7. So under this bill, there will be several months compensation for the tenants. Now, if the tenant passes away, the few months compensation would be crucial for the surviving family members for moving out. So please reconsider your position. We will do that. We will do that. Dr. Wendy Hung. Thank you. Cap 128, Land Registration Ordinance. Now we are scrutinizing Cap 585, Land Titles Ordinance. So in the future, there will be two parallel systems. So will they both be reflected in the BHU regime? Ms. Wong? Thank you. Both Cap 128 and 588 are referred to in the bill. Now, Cap 128 and Cap 585, their applicability depends on the definition of landlord. So the persons whose name is on the land register is the landlord. Now, Cap 585 will first apply to newly developed land. So in the initial years after the passage of the BHU regulatory regime, we will mainly rely on Cap 128. Still, we are including Cap 585 in the bill as well because we want to reserve some flexibility. In the future, in terms of identifying the landlord, we will rely on both CAP 128 and CAP 585. Mr. Andrew Lam. Thank you. I want to return to the definition for building. Now, according to your understanding, what kinds of structures or buildings do you mean when you are defining building? Ms. Wong, we have had consulted other departments. So we think that by using the term reference building plan, we can cover most types of buildings. But there are some buildings in Hong Kong, residential building, which don't even have the reference or the original building plans. These are mostly very old buildings. So for these relatively old buildings, they may not be regulated under the BHU regime. For these buildings which have seen many years of life, the building departments and the fire services departments would inspect these buildings to ensure their safety. So the BHU regime will cover most of Hong Kong's buildings as well as the government buildings to ensure that all conditions are met. Thank you. I just want to confirm this point for the public's benefit. So for pre-war buildings, Chinese tenement buildings without a building plan, they will not be covered by the bill. For pre-war tenement buildings, there are only several hundreds of them left in Hong Kong. Without the original building plan, it's impossible to compare the building plans. But as I said, other departments would regulate their safety. Mr. Tong Li Jie, second round. Thank you. Concerning prescribed fees, we have discussed the schedule concerning the fee. So what's the consideration behind the setting of the fee? Is it on a cost recovery basis? Ms. Wong. Yes, like Mr. Tong Li Jie said, we adopt a cost recovery basis. The figures have been arrived at after discussion with the Inland Revenue Department. And what about the exemption of the $3,000 fee? We have considered that principle as well. Having discussed the matter with the IRD understands that our position is to encourage early registration for BHU. So they have considered the level of exemption, that is full exemption, for the first 3 years. They find this acceptable. Thank you. Let's return to C3434, registration day. Next, registration day. In relation to a basic housing unit regulation, means the date prescribed under Section 1912 for the recognition. Next, registered flags means a flag for which a grace period registration is in force. Next, Code of Practice. Code of Practice issued in accordance under Section 84(1). Now, recognition date. Our next grace period, unless otherwise specified, it means a subject to paragraph B, the period mentioned in Section 9(3), or B, if the period is extended under Section 9(4), the period so extended. So that's 36 months after the registration period.
限期嘅登記
Then grace period registration
period means an application under Section 9(2), grace period, registration application, that is. Grace period, registration application period. Subject to paragraph B, the period mentioned in Section 10(1)(d), or if the period is extended under Section 10(2), the period so extended. That means the 12-month application or registration period. Mr. Lam Chan Shing, thank you. I'd like to ask a question about a code of practice. Of course, the provisions are under Section 84, but then I would like to clarify something about the code of practice, because it is not subsidiary legislation or legislation. Still, it has to be gazetted. I'd like to know the procedures for amending the code of practice so that there can be consultation prior to amendment. Now, amendments might involve changes to the basic or the minimum requirements, and the second situation where amendment is required is to fix the hiccups found under the code of practice, such as how to measure the size of a window and the definition of a light well, etc. There might be unforeseeable conditions that are only identified after the commencement of the legislation. So amendments to the code of practice might be quite frequent. I'd like to know the procedures. Ms. Wong. The code of practice is user-oriented, so we've started drafting the code of practice a few months ago. We are communicating with relevant professional bodies. The first draft is already available. Hopefully, within this year, we can complete the code of practice for publishing, so that before the mechanism comes into place on the 1st of March 2026, people know how to attain the minimum standards. So that's the first draft. We will keep in view the implementation. If we receive feedback from the industry that more guidelines are needed, then we maintain an open mind. We will continue to liaise with professional bodies where major principles are involved. We may even have to consult the council first. As regards how the code will be amended, it depends on the circumstances. If we talk about the technical details, we will first consult the professional bodies before amending the code. The code of practice will be uploaded to our website for public inspection. Any follow-up? No, thanks, Chairman. All right, Dr. Lo Wai Kwok. I'd like to clarify the following. Two definitions, the registration date and the recognition date. Now, the registration date, I'd like to know whether it's about the grace period, and the recognition date is the date when the BHU is properly recognized. Ms. Wong. That's correct. The registration date is for the purpose of the 36-month grace period. Starting from the 1st of March 2026 to the 28th of February 2027, the application can be submitted, and then we will inform the applicant that the registration is successful. Regardless of the date of registration, well, it has to be done within 12 months. The commencement date is the 1st of March 2026, and the 3 years that follow. So within the 12-month period, the registration has to be submitted, but the grace period will start from 2027, the 1st of March. until the 28th of February 2030. When it comes to the recognition date, now after the applicant has submitted his application, documents are vetted and approved, and the notification will specify the effective date of recognition, and that is the recognition date. So after registration, there will be an automatic grace period, and then the owner can start all the procedures for receiving recognition. Correct. Mr. Rincon, a drafting point. Grace period application. Now, this is very simple. Here, means an application under Section 9(2). Now, can you improve the wording? And you also have the recognition day application and application, or rather recognition renewal application. Perhaps I can invite our draftsman to comment. Well, this is a common way of drafting. Whether the Chinese term 所述 would be a better wording, we will come back to you later after checking other documents. All right, please put a marker here. Next, C3436 unit, a building unit. So we talk about premises in a flat regardless of the description. And then next is owner. Because for registration, application recognition, and recognition renewal application, it can be done by the owner or someone with the consent of the owner, and therefore we have to define owner here. As mentioned, we will follow the owners on our register under Cap 128 and 585. Now, owner in relation to any premises in the building means if the land on which the building is erected is divided into undivided shares and the entitlement to exclusive possession of the premises is attached to the ownership of one of those shares, specified undivided share a person, one who appears from a registered cap in the land registry under Cap 128 to be an owner of the specified undivided share, or two whose name is entered into title register kept in the land registry under Cap 585 as an owner of the specified undivided share, or B, otherwise, a person who appears from a register kept in the land registry under Cap 128 to be an owner of the land, or whose name is entered in the title register kept in the land registry under Cap 585 as an owner of the land. The next definition is operator. In relation to a subdivided unit means a person who lets the subdivided unit for habitation, or any other person who is from time to time entitled to receive rent for such letting. All right. Mr. Vincent Zhang. Thank you, Chair. I'd like to ask a question about the term operator. So the operator may be the owner or a real estate agent. Will they be kept? Will they be caught under A and B? So I'd like to know why you haven't put in specifically a real estate agent. So in future, if it is a relative of the owner, will it be caught by B here? Ms. Wong, thank you. B will cover exactly persons mentioned by Mr. Zhang, either a real estate agent or relatives of the owner. Since someone is entitled to receive rent, then he should know the kind of unit we're talking about, and he is duty bound to fulfill the basic or minimum standards. So the definition has taken reference from the definition in Cap 7. So why don't we specify the term real estate agent here, since they will be the majority here, but we think it is better to put the legal principle in the ordinance, that is, any person who is from time to time entitled to receive rent, and he is duty bound to comply with the BHU ordinance. Ms. Doreen Kong. Now for the definition of flat, can we make it simpler? In Chinese is comma and then 該建築物的. Can we make it simpler? Can we do away with the 3 words 該建築物的? And the definition for owner. I'd like to know whether mortgagee in possession is included. For instance, a mortgagee in possession has already taken possession of the flat, because you say that it must be someone who appears from a register kept in the land registry. What if a bank is the mortgagee in possession? What will be the situation? Because only the owner can apply for recognition. Now, if a bank would like to apply for renewal of recognition, it won't be able to do so. And as for operator, Mr. Vincent Zhang mentioned a real estate agent or relations of the owner. What about trustees and also banks? Banks are sometimes authorized to receive rent. And what about attorneys and lawyers? Will they be covered under B? Ms. Wong, and then Ms. Lee from the DOJ. Thank you. Ms. Kong asked whether owner would cover mortgagee in possession. We have already stated the definition here. Since mortgagee in possession hasn't appeared here, that it may not fall under the definition of owner. We will check the land registry and see who is the registered owner. And the second question is whether professionals who receive rent from time to time, then whether it be professional or real estate agent or a relation of the owner, if he is entitled to receive rent, then he has the duty to clarify or verify the purpose of the flat in question. When we come to Section 8 of the bill, offense, we have a defense there. There is a statutory defense there. If the professional is entrusted to receive rent for a certain flat and he has no knowledge about the status, and or he has no idea that it is a BHU, then it can be a defense. But if he has full knowledge that the flat has BHUs, then he has the responsibility to ensure that the BHU legislation is fulfilled. Mr. Ring Kong, please reconsider the point about mortgagee in possession, because that may create a legal vacuum. The reason why we have a mortgagee in possession is the owner has fled. There is no one to apply for renewal of recognition. And what about the tenants? They cannot pursue the owner because he is already out of the picture. The point about receiving rent. A very quick point. Many banks are receiving rent. In future, banks will not receive such jobs. Ms. Wong, I want to talk about mortgagee in possession. If a bank has already taken possession of a certain flat and the owner cannot be traced, if it is a BHU flat with tenants, then when we take enforcement action, we will look at the actual circumstances. The bank may have to enter into agreement with the tenants. The tenants may have to be evicted, and the bank should not renew a tenancy agreement before the situation is confirmed. If a tenant has left and then another agreement is entered into, then we may have to seek legal advice and see whether we have to take action. As for banks receiving rents on behalf of a certain owner, our position remains the same. The bank has to clarify the status of the flat. So we are of the view that the current definition should be kept. Can the DOJ reconsider Mr. Rincong's point about the drafting? Ms. Wendy Hong. The definition of owner and operator is related to the definition of subdivided units. For instance, I'm a tenant, I have rented a flat, and then I become the principal tenant and I rent out a room, a subdivided unit of the flat. Should I be considered an operator? Now, if I'm an owner, the flat is also self-occupied, but I have subdivided a part of the flat for renting out. Will that flat be regarded as a BHU? I think this point was covered when we discussed the policy aspect. Ms. Wong. Ms. Hong. We'll first look at the condition of the flat first. If the plan has been altered, so instead of a 2-bedroom flat, the owner has converted it to a 3-bedroom one, then, and if each room is let, then the owner is both the owner and the operator. That's the first scenario. And the second scenario is, after subdividing the flat, the owner has only rented out one unit. Then he will not be caught by the BHU legislation, because in some older buildings, there may, in a 2-bedroom flat, the owner has partitioned it into 3 for the children, and then if only one unit is rented out, then it will fall under the definition of BHU. But if there is only one tenancy agreement, then it will not be regulated by this bill. We are talking about more than 2 tenancy agreements before the flat will fall under the regulation of the BHU ordinance. What if the principal tenant has sublet one unit to another tenant? All right, a flat has been altered by the owner, and yet the whole flat is let to one principal tenant who sublet the one unit to another tenant. Then the owner, under the current drafting, might have committed an offense. However, there is a statutory defense if the owner has exercised due diligence in telling the principal tenant that the whole flat is let as a whole and no reletting is allowed. So if the principal tenant lets out the flat without the knowledge of the owner, then the owner is exempted. But will the principal tenant be regarded as an operator? Of course. Since he has sublet part of the unit, then he is an operator. What if he has only let out one unit? there is only one tenancy agreement, what will be the case? Well, if the principal tenant lives in one unit and let's say one unit. Now, if there are two tenants identified, then it will fall under the definition of BHU here. But if there is only one tenancy agreement, because there are two BHUs let, then it will be caught by this definition.
That will be regarded as two tenancy agreements, right? Yes, correct. This is exactly what we try to avoid. That is, we try to avoid people subletting a unit time and again. All right. Next, Mr. Andrew Lam. Thank you, Chair. Well, I'd like to talk about the definition of a flat. Flat, it's independent flat, whereas a house is an independent house. So now for this bill, we are talking about flat. We are not dealing with independent houses. Is that correct? Ms. Wong? Yes. For definition of flat, we say that this is premises of a building, whereas house, it should be an independent house. There might be 2 to 3 stories, and inside the house there should be an original building plan for the house. We will then look at how the house has been altered, if it's different from the original building plan, and if the owner sublet 2 or more units to other tenants, then this would fall under the BHU regulatory regime. So it is most important for us to look at the original building plan before we take any action. All right. That means the present bill is to regulate not just flats, but also independent houses. Is that correct? As long as there are original building plan for the houses, you will then look at the original building plan and then see whether it has been altered or sublet. I think whether it's a flat or a house, it doesn't matter. So it depends on the tenancy agreement. Ms. Wong? Yes, correct, Chair. It is difficult for us to foresee different types of building premises that might appear in the future. So we would look at the original building plan for the premises first. Yes. Well, in the future, or in the bill itself, I can see different sections or clauses that refer to the term flat. I just want to clarify this point. All right. Next, Mr. Leung Kwong. Thank you, Chair. I'd like to follow up on Dr. Wendy Hong's question regarding the owner and the principal tenant. For instance, an owner has a sublet a unit to a principal tenant, and then the principal tenant might subdivide it into, for instance, 3 units, and then sublet these units to other tenants. But before the principal tenant sublets the units, there is no need for him to do any recognition for the units. Well, as soon as there are 2 or more tenancy agreements, then that should fall under the regime. Is that correct, Ms. Wong? Now, first of all, let's go back to the definition of SDUs. That is, for a premises, there is an original building plan, and then alteration has been done to make the unit become 2 or more SDUs for habitation. So that's the definition of a subdivided unit. And after modification of the flat, we would have to see whether there are tenancy agreements That is the units, whether the units are subdivided and then let out to tenants for habitation. That would be under the regulatory regime. However, if the units are to be used for storage, it will not be fall under our regime. And if the units have tenancy agreement with 2 or more tenancy agreements, that would be under our regulatory regime. Well, what about the principal tenant is still living there? And sublet a unit, that means there is only 1 tenancy agreement. And what if the principal tenant is not living there? Well, the principal tenant already has a lease with the owner, right? He's entered into a tenancy agreement. Whether he's living there or not, it's not our business. He already has a tenancy agreement. That is 1. We count it as 1. And then if he sublet the units, that we will have to go in and check whether there are 2 or more tenancy agreements. As long as there are 2 or more leases in place, then that premises would fall under our regulatory regime. Well, of course, we will take into consideration all objective evidence. And for instance, if the subdivided unit is used as a storage, then that could be a defense. All right, next, Mr. Rincon. Thank you, Chair. Regarding the situation of the principal tenant, whether he should be an owner, I don't think there is any confusion, because it's very clearly stated who should be responsible. Well, I have a point about the drafting of the bill. Regarding owner, A2 and B2, it says A2 whose name is entered in the title register kept in the land registry under cap 585 as an owner of the specified undivided share. I have a point about the Chinese version, the drafting of the Chinese version of the bill. I think it's a bit cumbersome. Yes, perhaps the DOJ could consider this point as a drafting point. I understand that the legal advisor has submitted a letter to the administration on the bill. Yes, regarding definition of operator, especially on B, any other person who is from time to time entered to receive rent for such a letting. We'd like to ask whether real estate agents or relatives or friends of the owner are under this definition, whether they are operator. They might be receiving rent on behalf of the owner. So, do you think that these people should be regarded as operator, and whether they should be held responsible if there is any problem arising in the future regarding the subdivided flats? Well, for instance, if the unit has not been properly registered, or it has not been recognized, or has not received the recognition document, we'd like to seek clarification on whether such persons, for instance, real estate agent or relatives of the owner, should be held responsible. Thank you, Chair. Yes, this is our policy intent as well. We understand that in the rental market of subdivided flats, there are different types. We don't want to leave any gray area or loopholes for people who might escape from our regulation when they sublet the SDUs. Well, if a person sublet a unit and if he knows that this is an SDU, then he should be held responsible for ensuring that the unit has met the minimum requirement of our BHU regulation. Well, in the future, we will have a specific web page that will list out or set out the addresses of these premises that have been recognized. So if the owner or operator wants to sublet a unit, they can go to the website and check against this list to see whether the unit has been registered or properly recognized. Thank you. Perhaps you should set these out in your reply to our legal advisor. All right, Ms. Kong. Next, also about the definition of owner. If these kind of SDUs are left behind by some elderly people who have passed away, and the beneficiary would be in possession of these SDUs. Well, in the bill, do you have any coverage on such case for the beneficiaries who receive these SDUs? Yes, we do have coverage on this situation. For instance, a person who is a beneficiary and has received one of these SDUs, as long as he knows that this is an SDU and which should meet the minimum requirement of our regulatory regime. However, if there is tenants living in the premises, he should try his best to inform the existing tenants to know that when the lease expires, the tenant has to move out, because the beneficiary or the new owner of the premises has to do some alteration or modification of the units so that it could meet the basic requirement of a BHU. Well, we will have to see whether this new owner has tried his best to do all these steps. Thank you. If there are no further questions, let's move on to page C3438. Thank you, Chair. Next term is approved building plan. Subject to paragraph B, a plan approved by the building authority under Cap 123 or in relation to a building to which Cap 123 does not apply under Section 18(2) of the Housing Ordinance, Cap 283, a plan prepared by the Hong Kong Housing Authority. Next, authorized officer, meaning a person appointed under Section 74(1). Next term, basic housing unit, referring to a subdivided unit for which a basic housing unit recognition is in force. Next, basic housing unit recognition, meaning a recognition given under Section 16(1) or renewed under Section 16(3). Basic housing unit recognition application, meaning an application under Section 16(1). Next, basic housing unit renewal application, which means an application under Section 16(3). Function, including rights and obligations. And building related, ordered or notice, means an order under Section 23, 24, 24A, 24AA, 24B, 25, 26, 26A, 28, 7 or 28 of Cap 123. Or B, a notice under Section 24C, 30B, or 30C of Cap 123. Next, about Cap 572. Fire safety related order or direction means a closure order that's defined by Section 2(1) of Cap 95F, or prohibition order, closure order, fire safety compliance order, fire safety direction, and a prohibition order, etc. Thank you. First, about the approved building plan. The Chinese version, 獲准 and 核准. Is there a change in the use of the word, the Chinese term? The English term is the same, approved building plan. However, I noticed there are some change in the Chinese term. Next question about the fire safety related order or direction. Understand that it is on page 3463, which authorizes the secretary to issue such order or direction if the premises has imminent fire, imminent threat or danger. So it depends on the situation. The secretary could consider whether the registration should be cancelled or approved. So relevant parties, including the tenants and also the professional involved, should understand these. I just hope that the direction could be clearer, or the definition of these terms could be made clearer. Ms. Wang, yes, we understand that point. In the future, we will have the code of practice. If a building has has potential fire hazards or safety hazards, the housing department may have to do enforcement actions. And for BHU, of course, we should not give proper recognition to such premises if it is in danger. So we will not approve the application if that is the case. In the future, we will have clearer code of practice so that relevant parties will understand fully our requirement. As regard approved building plan, the Chinese term, I'd like to defer it to our colleague in the DOJ. Mr. Lee? Thank you, Chair. The Chinese term 批准 is used in the existing ordinance. But for the existing bill, we use the term 獲准 in order to show that this is in a passive voice. Well, Chairman, I'm not sure because I'm not a drafting professional, but I think since this terms for definition, I hope that it could be made more consistent. I think I will not go on this point. Ms. Kong, Doreen Kwan. Thank you, Chair. I'd like to ask a question about building-related order or notice. How come 27A, Section 27A is not included? Cap 1, 2, or 3, Section 27A, how come this is not included under the term here? And also Section 33, it's not included here. In the building ordinance, if the government has paid to rectify a situation, and if order is issued or notice is issued under 33 so that the owner has to pay up to the government, it should be included here.
Ms. Wong? Now, the orders we mentioned are orders issued to the specific flags. Now, for a slope, the order would relate to the building itself. So in terms of auditing conducted by the specified professionals, they need to confirm that the principal flags and the flag itself do not have any standing orders. For slope, it is mostly related to the building itself. So we haven't specified that the auditing reports need to cover slope as well. But in approving each case, if we find that there is a standing order in relation to slope under Section 27A, then we will consider whether we will approve the application. On Section 33, I will defer to Mr. Chan. Concerning Section 33, arrears of payments to the government, that's the fee recovered by the building department on works done on the landlord's behalf. So that's in relation to the safety. That's not in relation to the safety of the flag itself, so we do not intend to include payment order in the bill. I invite the government to reconsider your position because in subsequent clauses, the word liability is mentioned. Section 33 is such a liability. So your position would be recovering the expense paid on the landlord's behalf as early as possible. So by including Section 33 here, you can speed up the process. Ms. Wong, well, I thank Ms. Doreen Kong for her suggestion. The overarching principle is on ensuring the safety of the flag itself. So on including Section 33 order in the provision, we will reconsider it after the meeting. Let's return to 3440, Mr. Chan. Thank you. Next renewal date. In relation to a BHU recognition means the date specified under Section 23(2) for the renewal of the recognition. Next, subsection 2. That's in relation to the further details in Schedule 1. Now, next, about the word settled. Now, on whether an application or a recognition is settled, it depends on the transitional arrangement. So it relates to three situations. Now, if an approval is given to the application, that's settled, and also application rejected. If there is no appeal filed when the expiry date is reached, it is also settled. 3, an application is rejected and then there is an appeal filed. A decision made by the appeal board would be considered settled. So please explain clause 4 as well. Now, if the entire subdivided flagged is leased out, it is not an SDU. Now, clause 5. The footnotes of this bill does not carry any legal weight. Now, clause 85, prosecution period for the offences, there is also a footnote. Dr. Starry Lee. Now, about the arrangement of the renewal date. Now, I understand what settled means. When it is proved, then it is settled. But it's there a possibility that an approval has been given, but the grace period has expired. is that also considered settled? Now, considering the transitional arrangements, for example, an application is made to the housing department, but more documents are required, and also a visit to the flat is required, and it takes time. So for a recognized flat applying for a renewal, the recognition has expired, but since an application is made to the housing department, then for such a case we will consider the recognition still valid until the renewal application is settled. If it is decided that the flat no longer meets the requirements, then the recognition will be cancelled. So during the transitional period, there are cases where the recognition is still being processed. For these cases, the recognition still stands. Now, subsection 2 there are conditions on whether a SDU fulfills the minimum living conditions. Now, besides Schedule 1, B says the principal flat must comply with all the requirements set out in the schedule concerning the flat. Now, say there is 5 rooms in the flat, and if I submit recognition application for the principal flat, but the other 4 flats are not processed yet, then this provision will prohibit such a practice because it sets flats instead of subdivided units. Now, so tenancies may end on different dates, so you need to allow the operators to modify the SDUs one by one. But according to subsection B, it seems that you are prohibiting the operators from conducting modification works one by one on the units. So on submission of an application, we will only consider whether the principal flat fulfills the minimum standards. But there are also requirements in relation to the flat itself, for example, the width of the corridor and the installation of fire extinguishers in the communal parts of the flat. So these are requirements applicable to the flat itself. So even if the principal flat or subdivided unit A meets all the minimum standards, the operator still needs to fulfill the requirements for the communal parts, for example, the width of the corridor, and so on. So despite the requirements of ventilation or separate toilets being met, there are also requirements for the main flat, like the fire escape and so on. So if that requirement is also met, that would be fine. The landlord does not have to submit application for SDU B or C altogether. That would be great, but from subsections B, I couldn't guess the explanation you just told me. So please modify subsection B to make that more clear. Yes, we will revisit the drafting of this subsection. Mr. Tony Chair. Now, BHUs must fulfill the requirements under Schedule 1. Now, about the measured floor area, there is a requirement for the BHUs to be enclosed. So, for some tenancy, Sometimes the areas not enclosed inside the flags would be leased out to, say, the tenants of Unit A as well. So will those areas be in scope? Ms. Wong, we have had some similar discussion on the last occasion. So when we come to the definition for SDU, we will elaborate that. The concept of enclosure is important. Now, if the building plan of the original flags is amended or changed by the landlord, if the unit is enclosed to a large extent by whatever means, we consider that a subdivided unit. Failing that, the scope of the BHU regime would be too large. For example, simple partition installed by the landlord with a low degree of enclosure. So the definition of an SDU is a unit to a very large extent enclosed. Then those requirements for BHU would apply. Chairman, I raised my point to prevent abuse. An 8-meter square large flag divided into 2-meter square large flags, but there are also communal parts not enclosed as well, so you have to be aware of that. So for the areas outside of the enclosure, they will not be counted towards the 8 square meter large area. Dr. Starry Lee. Now, the definition for reference building plan, have we come to that yet? No, not yet. Now let's move on to clause 3. Next, meaning of reference building plan. So some explanation here. It is for identifying whether there are SDUs in the flags to see whether that would be regulated by this bill. Now, for the purpose of this ordinance, an approved building plan is the reference building plan of a building if the approved building plan is the latest one for the building as at A, for a pre-existing building, the Gazetted date, or B, for any other building, 1, the date on which an occupation permit is issued under Section 21 brackets 2A of Cap 123 for the building, or 2, the date on which the approval or consent to occupy the building, however described, is issued by the independent checking unit under the office of the Permanent Secretary for Housing. Now, Now, if the plan is approved but the work is not completed until the Gazetted date, then the plan will not be deemed as the latest building plan. Dr. Lee, Chair, my question is, when I was a district councillor, I was told by some complainants that the buildings are very old, like those buildings where SDUs are usually located. Do you have a building plan in your department? Second, a snapshot of the flags will be taken on the Gazetted date. Is that how it works? Do you take a snapshot of the status of the flags whenever there are updates or to the plan? Because according to many professionals, they can't find such a plan on the database. Ms. Wong, concerning whether there are building plans for all the buildings, well, most of the buildings have building plans, but there are several hundred buildings, mostly dated back to the pre-war era. They don't have plans. Those are very old buildings. So the building departments and other departments will look after the safety of those buildings. So we think the definition in this bill will be sufficient for ensuring the safety of BHUs. On the Gazetted date for pre-existing buildings, we will use the building plan submitted when an occupation permit is issued to the building. Now, changes to the building plan would be recorded on the database of the buildings department. For new buildings built after the Gazetted date, we will refer to the plans submitted to us when an occupation permit is issued. The point of this arrangement is to prevent landlords from seeking an approval from the building department after the Gazetted date to bypass the BHU requirement. But that would be very exceptional because for most buildings there are building plans accessible by the public. Dr. Starley, so does it mean that you are not regulating any buildings without a building plan? Second, I've heard cases now, because of historical background, the existing layout is different from that in the building plan. So that's a very old resident who has been living in the building since the occupation permit is issued. Some walls have been built beyond the coverage of the building plan. So for these cases, I wonder how you will deal with them. My constituency is very old, and there are some cases like that. Ms. Wong? Yes, we agree that there may be quite a number of such cases. From a law enforcement perspective, however, we will compare all the available documents in the government's database. So we will refer to the building plan kept by the buildings department as the reference building plan. So concerning the case mentioned by Dr. Sarah Lee, the layout of the flags is different from the building plan kept by the building department. That would fall within the definition of modification works conducted on the flag. So if the landlord still wants to lease out the flag as a BHU, I advise them to confirm the building plan kept by the building department. So is the building plan kept by the building department accessible to all the public? Thank you. Mr. Andrew Lam, I think you have to pay attention to several points when you are enforcing the law. Now, besides referring to the original building plan, you would also check the updated building plan when modifications are made. Now, but there are also other old buildings, for example, old buildings with terraces sealed off. Now, residential terraces cannot be used for accommodation according to the law. So you have to make this clear because this situation is quite common. However, if you are telling me that in the future, in enforcing the buildings ordinance, there will be flexibility in handling unauthorized building works, these UBWs will be tolerated, then that would be fine, but you have to clarify that because that would affect the supply of BHUs in the future.
Ms. Wong, yes, we will look at the building plans. If the original building plans indicate that there is an unauthorized building structure, then we will not regulate such a flat under this mechanism, because the mechanism is to recognize flats that are can be regarded as BHUs, and it will be for the buildings authority to take action. Now, take the balcony as an example. It itself is not an unauthorized structure, but enclosing it is illegal. You have to make this very clear to professionals, because there are complications. As Ms. Sarili said, the mode of regulation years ago was very different from what it is now, because years ago the balcony may already be enclosed by the developer when it was first sold to owners. So you have to be very careful with your guidelines. Thank you. I note the point made by members, and we will make it very clear in our guidelines types of structures that will be regulated under this mechanism and those regulated under other mechanisms, to make it clear to professionals. Mr. Vincent Zhang, yes, what about buildings with no building plans? The administration told us that they will not be regulated because we have hundreds of pre-war buildings. Given that we have hundreds of pre-war buildings, many of them may be operating SDUs. Assuming that they have a few thousands of SDUs, how will you deal with them? Now, because these buildings do not have any building plans, they will not be regulated. Still, pre-war buildings are rather old buildings. We believe the Buildings Authority will have regard to the overall safety of the buildings concerned. We will liaise with the BA. If in our enforcement action we find out that there are no plans for a particular building and therefore the flat cannot be recognized under the BHU mechanism, and if there are irregularities or safety hazards in the flat concerned, we will let the owner know, so the member can rest assured. Ms. Sarili, in the small area I serve, I've heard from more than one building that the building plans are different from the flats they are occupying. So you may follow building plans you have on your register, but I believe there will be disputes in the future. So please consider the actual situation. The primary concern should be safety, because I was told in one case that the location of the wall is in fact different from what was indicated on the plan. I believe that is not the problem of a single building. Due to historical reasons, there can many buildings may be involved, and many old buildings do have SDUs. Ms. Wong, yes, we are aware of the point made by Ms. Sarili. For old buildings, if they have safety hazards, the buildings department will certainly take enforcement action. If a flat wants to be operated as BHUs, the owner must meet our minimum standards. Otherwise, they may commit offences under this bill. But the point is, the alterations were not made by the owner, but they were already there when they occupied the flat. But I won't argue with you here, but I think the alteration was not done by the owner. Now, the point is not who made the alterations. It's an objective point. If the partition in a flat is different from what's indicated on the building plans now, the current owner has to ensure that the standards in the Big Chu bill is fulfilled. So we're not talking about the owner itself. If the situation in the flat is different from what is indicated on the flats on the plans, then the owner has to ensure that the requirements in the BHU mechanism is fulfilled. All right, thank you. Clause 4, meaning of subdivided unit. Now, if a flat of a domestic building is partitioned or be partitioned by means of a solid wall or metal wall, etc., and if it is re-partitioned by means of walls to the extent that the layout is different from what is indicated in the plan, and if after subdivision there are more than two compartments that can be used for rental purpose, then each compartment is regarded as an SDU. As we all know, there are different ways of partitioning a flat, and therefore in this provision we have not specified it must be a fixed structure, whether it is vertical or, and regardless of the material, they are not important for the purpose of this provision. This is to ensure that people will not abuse the loophole by using materials not specified in this bill. And for rooftop, terraces, and also gardens, they may be regarded as part of a flat in the plans. So for structures on these places, they will be exempted so that they will not be legalized. Mr. Andrew Lam. I'd like to follow up on my previous point, that is the difference between a flat and a house. You talk about a flat of a domestic building. Now, a house is a domestic building. This is very clear. So what is meant by a flat of a house? My limited experience in a land or town planning ordinance, the definition of a flat and a house are very clear. So if you want to include a house, make it clear here to avoid unnecessary dispute in the future. Ms. Wong, please note this point, because it's not the first time Mr. Andrew Lam made this point. Mr. Tony Tse. So I'd like to talk about the point, substantially enclosed. So what do you mean by enclosed to a certain extent? Because it may be enclosed at the lower part of the wall, but not at the very top of the wall. One of the requirements of one of the definitions of a big U flat is with no less than 2 tenancy agreements. Now, if in a flat with 3 bedrooms and 2 bathrooms, if the partition wall between 2 rooms are removed so that 2 rooms share 1 bathroom, and then the other bedroom is also rented out, that means there are 2 tenancy agreements. I'd like to know whether there is a need to include this arrangement in the bill. All right, enclosed to a certain extent, Mr. Jie would like us to make it clear what is substantially enclosed. Now, if the partition is such that a certain space is created, then it is a subdivided unit. But there can be different ways of enclosing a certain space. So if we say wholly or substantially enclosed, then what if there is a gap of 1 cm? What if the enclosure is only up to eye level? So we will address these points in our code of practice. We will give examples for relevant parties to note. And why do we have to look at flats that are combined, or compartments that are combined? Because we want to ensure that people cannot use our loopholes. For instance, from 3 bedrooms to 2 and 4, if there are 2 tenancy agreements, then they will be regulated. But if after combining 2 bedrooms, the large bedroom is self-occupied, is owner-occupied, and the remaining bedroom is rented out, then it will not fall under the definition of BHU flat. So the principle is, after alteration from the building plan such that the layout is changed, and if only 1 compartment is rented out, then it will not be regulated by this bill. Well, there is a definition for SDU under the Landlord and Tenant Consolidation Ordinance, and you have a very detailed definition here as well. Can I say that the two are not contradictory? Yes. For the Landlord and Tenant Consolidation Ordinance, the definition is much wider. It's about a residential flat, and if part is rented out, then it will be caught by the definition under that ordinance. It depends on the purpose of regulation, because when the ordinance was enacted in 2022, the purpose was to deal with bed space compartments and bed space apartments, and also SDUs, to allow security of tenure of tenancy for these people. But here we're dealing with a different issue. So in a residential building, or in the residential portion of a composite building, in places where it is legal for human inhabitation, we will regulate such parts. Mr. Leung, now if my understanding is correct, now if count 1, 2, 3 is breached, that means that there is an illegal, unauthorized structure. So the compartment cannot be regarded as a subdivided unit. Now we're not talking about amendment to cap 1, 2, 3. Amendment to the ordinance may be possible in the future, but in future, if a certain unauthorized building structure is no longer regarded as such, then will the compartment automatically fall under the regulation of this bill? So if there is amendment to Cap 123 to the extent that an UBW can be accepted if it is safe, and if the compartment is rented out and is being inhabited, then will it be regulated by this bill or not? If under Cap 123 it is regarded as a UBW, it cannot be recognized under the BHU ordinance. But if we're talking about a tolerated UBW, it is still illegal, it is still unauthorized. So such an SDU cannot be recognized under this bill. The UBW is only tolerated, but it is still unauthorized. Mr. Leung, you have to be very careful with this point. If UBW is tolerated under Cap 123, there may be no regard to whether there is a window or whether it is being habitated. Then people may abuse the loophole. The SDU is less than 8 square meters. People may continue to live there because it is a tolerated UBW. So you have to be very careful about this point. All right, please note this. Any more questions? If not, can the legal advisor advise us on clause 4? Yes. 41B, meaning of subdivided unit. Among the compartments, at least 2 are designed for each being the subject of a separate domestic tenancy. How did you confirm whether it is designed for each being the subject of a separate domestic tenancy? And also, members also mentioned the point about substantially enclosing a certain part of a building. Do you have the minimum height of a partition? So how do you confirm whether it is substantially enclosed? Now, in 41B, we talked about compartments designed for each being the subject of a separate domestic tenancy. This is because there may be a compartment to be used for a toilet then or a bathroom, then it is not meant to be a domestic tenancy. And as for substantially enclosing a certain part of a flat, we will provide the minimum. If we provide a minimum height required, that will create a loophole for people to abuse. Now, for instance, if we say it is at least 1.8 meters tall, then people may just make it 1.7. So, to decide whether it is substantially enclosed, now if there is a gap of only 1 cm, it will be considered substantially enclosed. But if it's only up to eye level, then it may not be regarded as substantially enclosed. The point is not to leave any gray areas as loopholes. Any further points? Ms. Judy Chen. Yes, I understand that you don't want to make it too rigid. So you do not specify the material, etc. used in such compartments. But I understand that there are boarding houses for foreign domestic helpers and also boarding houses for overseas students. The partitions may be opened daytime and enclosed at night time, will they fall under this category? Now, foreign domestic helpers are supposed to live in. They should stay in the employer's home. So boarding houses for foreign domestic helpers are legal. And accommodation for foreign students. If the hostel or dormitory is one managed by the university concerned, it will not be regulated under this bill. Is it clear?
For foreign domestic helpers quarters, well, I understand that when a foreign domestic helper is seeking employers during the interim period, they might need this kind of hostels to stay in. All right, if there are no further follow-up, I'd like to invite Mr. Chen to go on. Thank you, Chair. Clause 5, application to contractual licenses. We treat a contractual license as a tenancy. So a person who grants the contractual license is to be regarded as a person who lets the premises. And we want to make sure that people would not make use of a contractual license as a loophole to sublet a premise or a compartment for people to live in or for habitation. Mr. Ring-Kwong? Chairman, if I remember correctly, please correct me if I'm wrong, according to the present tenancy control ordinance, it seems that there is no mention of this contractual license. So for this type of people, they do not need to fill in AR2, but then they will be under the regulation of this regulation. Is that true? Ms. Wong? Yes, in the tenancy control ordinance, contractual licenses are not included. But then when we were working on the BHU bill, we find that there are different types of tenancy in the market. In order to prevent that people make use of this provision as a loophole, we deliberately put in this term. That is, a person who has contractual licenses do not have an exclusive possession. Or some people may say that I'm not entering into a tenancy agreement with with my tenant. This is just a contractual license. So we want to plug this loophole, and that's why we have clause 5 here. So it says clearly here that for this kind of contractual licenses, they would be regarded as a tenancy. All right, Chair. Then a license would not need stamp duty. Only tenancy agreement needs to have stamp duty paid. So does it mean that you have to ensure that this is a tenancy? That means they have to apply for stamp duty, or they have to pay stamp duty for that. Is that true? Well, whether they have stamp duty or not is not our focus. Our focus is on whether there is a tenancy agreement or whether there is a contractual license. If there is a tenancy agreement, it could be a written one or a verbal one. If it is proved that they have this kind of agreement between the owner and the tenants, then it will fall under our regulatory regime. Well, Chairman, I have a follow-up question. The Secretary General just now mentioned a point. It rings a bell to me. You mentioned about the difference between a license and a tenancy agreement. You talk about exclusive possession. So if an owner has a unit and then petition it, but then the license states that you as a tenant would not live necessarily in Unit A on day 1. if you come in on day 2, I might allocate unit B for you. So would that be under your regime as well? Yes, correct. That would be under our regulatory regime. Okay, thank you, Chairman. Any further question on Clause 5? If not, let's move on to Clause 6. Thank you, Chairman. Clause 6, disapplication. This ordinance does not apply to any premises specified in Part 2 of Schedule 4. I suggest that we move to C3636, Schedule 4. Schedule 4, excluded premises. So excluded premises include the bed space apartment, hotels, guest house, residential care homes for elderly or premises with disabilities, residential care center, dorm or hostels managed by schools or universities, premises provided by employers or non-profit organization for providing social services. So these would be excluded premises. We've also entered PRH flats, SSFs, transitional housing, and LPH, because these are the public housing resources which cannot be sublet. So these would be included under excluded premises. And also, in order to foster town renewal, we also exclude the flat for renewal. Mr. Tony Se. Thank you, Chair. Just now, you mentioned that there would be excluded premises because those premises have already been governed by other ordinances or regulations. I mentioned earlier on about the B&B or bed space apartments. You mentioned that this is already governed by the hostel ordinance. But then in Schedule 4:15, can you perhaps give us further detail? Schedule 4, number 15. Yes, we like to leave some flexibility. And that's why we have number 15 here, because we find that from 1 to 14, all these premises could be excluded. However, we could not rule out a possibility that in the future there might be premises that are not exactly the same as what we have described in 1 to 14. And that's why we have 15 here, so that in the future, if it is found that there are some premises that should also be excluded, we would have them dealt with under this clause. Well, Chairman, 15 mentions that any other premises similar to the one specified in item 8, 9, 10, and so forth. What sort of worries do you have, or what are the concerns that you have in including number 15 here? Well, there is actually a recent case in point. For instance, in 13, it says a dormitory or hostel that is managed by a school or a university or any other institution that provides post-secondary education as defined by the Education Ordinance. We understand that the Development Bureau is encouraging the conversion of a hotel or commercial building into student hostels. So there is a policy support for this move. So under this situation, those premises would fall under 15. That is for the commercial building converted hostel for non-local students' habitation. And exactly because we've seen this kind, or we foresee this kind of possibility, that's why we believe that we should have a provision in 15 here, so that these premises would be excluded. Mr. Rincon? Well, Chairman, I'd like to ask about number 14. Section 14, it says, any premises that are used for the provision of sleeping accommodation by an employer to his or her employees and their families. Would there be any abuse here, for instance? Well, I might just employ a person, and then I could have my premises excluded from the regulatory regime. It is not difficult for me to just employ a person and then provide sleeping accommodation to him. And for Section 15, it says any other premises similar to the ones specified in 8 to 14. Item 8 to 14 are, especially 8 and 13, are the results of the existing regulations. Could you perhaps specify that those are the premises described in relevant regulations or ordinances? Yes, in item 14, those are the premises provided by employer. We would require the such premises to be owned by the employer. Only under that circumstance could he let his employer live in that premises. So first of all, the premises must be owned by the employer. It could be a subdivided flat, and he could let his employee live in one of the units or one of the subdivided units. Second point on item 15, could we consider giving further details? For instance, premises described by other regulations or ordinances. We could consider that, but then if we have to set out particular regulations or ordinances, it might not be flexible. It might not serve our purpose because we want to leave some flexibility in the future. But then, that said, we will bring your Ms. Kwang's views back for reconsideration. Well, Chairman, in item 14, I still have some reservations. For instance, for the construction industry or the food and beverages, hospitality industry, if their hostels are excluded, then is it in line with your policy intent? It seems that there is a big loophole left here. I'd like to raise my concern here. It's not about the drafting matter. Thank you. Ms. Wong, please take this, note this, and then bring it back for reconsideration. Mr. Andrew Lam. Thank you, Chair. I understand that this bill will not cover the traditional houses in the new territories, the so-called village houses. Why don't you specify this point here so that in the future there won't be any confusion? Oh, thank you. Yes, regarding the village houses in the new territories, they do not have a building plan. So when we were discussing about the definition, we mentioned about the building plan. But for these village houses, they do not have a building plan. So we would not be possible to decide whether there are subdivided units there. So it's not, will not fall under our regime. Yes, I understand that you do have an exclusion here. So my suggestion is that perhaps you could set it out more clearly, saying that the village houses are exempted or are not included under this regulation. Yes, we would bring this back for reconsideration. Ms. Judy Chen. Thank you, Chair. I also like to follow up on the question I just raised. About the accommodation for foreign domestic helpers. Well, of course, if they already have an employment agreement, they should live in the premises of the employers. However, there might be interim period whereby the domestic helpers have not found an employer or are not engaged in an employment agreement yet. And also there might be some agencies who could provide temporary accommodation for these helpers. I'd like to ask whether these would be excluded from the bill. Could you perhaps add them on? As long as they have declared such accommodation, then their premises should also be excluded from your regime. Well, we have to see whether these so-called foreign domestic helpers hostels are legal or whether they have met with our minimum requirement. We want to ensure that there are safe and reasonable living conditions for people's habitation. So it is difficult for me to lightly promise you to say that yes, we could exclude the foreign helpers to hostels from our regulation. It is not possible for me to do it. We have to really look at it case by case and see whether those accommodation are up to standard. All right, thank you. When you were responding to the point on students' hostel, I'd like to ask whether local students' hostel should also be included. Yes, both local and non-local students' hostels. We have a lot of non-local students, so I believe that there are a greater demand for the hostels for these non-local students. However, if there are hostels for local students, they should also be included. Right, Mr. Lam Chen Sing. About a decade ago, there are non-profit organizations who promote lighthouses. For instance, there might be some owners who are very kind-hearted and who want to let out some of their rooms in their own premises to the grassroots. Of course, I have visited some of these some of them are in very good condition. And for instance, they have not made any alterations. There are originally 3 rooms in the flat, whereas some others may have been altered. But then these are owned by social enterprises or non-profit organizations. The light B flats, would they be excluded as well? Yes, about the light B flats, these are the predecessors of our transitional housing. We understand that there are non-profit organizations who would like to let out these premises to low-income groups. We, of course, have to check whether they are properly operated by non-profit organizations. Yes, please take a look at these premises as well. Thank you. We have 2 more colleagues who have pressed the button. I think we will let them speak first before we take a break. Mr. Vincent Chang. Yes, about exclusion. Whether certain premises should be excluded, I think we could think further. The hostel ordinance and also bed space apartment ordinance, they are interrelated. I believe that the administration don't want to see the situation of the bed space about the BHU being turned into bed space apartments. How can you clearly define which is which? Because different departments will be responsible for enforcement. How Can you perhaps make it clearer what is a bed space apartment, what is a BHU, and what is an LPH?
Ms. Wong. Flags and bed spaces are flags regulated under the BHU regime and the Hotel and Guest House Accommodation Ordinance, and bed spaces. They have very different positionings. Now for BHUs, there are subdivided flags up to a certain standard for lease. For bed spaces, the line is drawn at 12 beds in the flag. Now, according to the HYAB, they think the 12 beds limit is appropriate, but subject to the passage of the BHU bill. The HYAB will consider amending the requirements to align with the minimum living conditions in the bill. Now, short-term leases of rooms in guest houses are another thing. They are regulated under the Hotel and Guest House Accommodation Ordinance. In law enforcement, we will give regard to the actual circumstances. A landlord cannot dodge the regulatory regime just by claiming that there are BHUs or other kind of flags. Mr. Vincent Zhang, I would like to elaborate on Mr. Lam Chen Sing's point. Now, a flat can be rented or let by a non-profit making organization operating on a non-profit making basis. So can I just simply establish an NGO and let my flat? There are a lot of room for interpretation. Ms. Wong. Now for number 6, it is a flag led by a non-profit making organization operating on a non-profit making basis. So even if the flag is operated by an NGO, if the operational model is a profit-making one, the flags will not fall under the scope of Section 6. So just being an NGO doesn't mean you automatically enjoy the exemption under the BHO regime. Several other members have pressed the button, so let's adjourn this session of the meeting here. The third meeting is adjourned. At 10:45, we will start the fourth meeting.